with y'all today. Madam Chair, there is an amendment that writes the bill and several people who would like to testify on the bill. How would you like to proceed? You want to?
Let's put the amendment on, please.
Okay. I have a drafting code 4446.
Okay. Okay, properly motion and second. Let's go ahead and put it on. All those in favor of adding Amendment 14446 to House Bill 2936, say aye. Aye. Those opposed, no. The ayes have it. You are recognized on House Bill 2936 as amended.
Thank you, Madam Chair. Members, last year I was in conversations with some friends about the importance of the family and parents, that I have felt like I see society kind of eroding some of the importance of the nuclear family, parents being involved in children. I've seen some of that, society kind of eroding that. As I started to look into it, I talked to people, come to find out that Tennessee is not really known for enshrining in law the importance of the family, such as parental rights are involved. The more I dug into it, the more I thought there are ways that we could strengthen our code, our Tennessee code, and put more emphasis on the family and the importance of parental rights. With that being said, I know there are people here for the bill and against the bill, and if it's good with you, I'll step away and let people talk on the bill.
Without objection, we're going to go out of session, and we're going to ask Ms. Connie Reguli to come forward and state your name and who you're with, please. And you have 3 minutes.
Good morning, committee and chairman. My name is Connie. Family Forward Project. I stood in courts across the state for 3 decades, helping families weave through complex legal challenges. I'm here to oppose 2936 as written, the Families' Rights and Responsibilities Act, and any legislation that attempts to enumerate parental rights and then provides that the government can slice and dice those rights away without meeting the constitutional burden that a parent must be proven unfit by clear and convincing evidence before the government can intervene. The bill has 2 sections, one creating an entirely new code section, and the second buries rights and exceptions in Title 63, the Health Care Code. First, definitions. The bill defines a parent to include an individual who's been granted decision-making authority over the child under state law. Decision-making means power granted to a non-parent. I assume this was intended for legal guardians. However, a guardian is not a parent. By statute, they are granted enumerated decision-making authority in a court order, and their rights are limited by that court order. Second, the bill goes on to outline all of the exceptions to parental rights. The word unless is used 5 times. And then the slippery slope section of when this does not apply includes that a parent gives a blanket consent or, quote, a government entity or any other person reasonably relies in good faith on an individual's representations that the individual is the parent of a minor or has otherwise been granted authority to make decisions regarding a minor's care under state law, which can roughly be translated in layman's terms as to, oops, that person told me it was okay. And then there is this exception, meaning that there's no parental rights, quote, services provided to or information is received or maintained about a minor enrolled in an institution of higher education or a minor participating in a program for which the minor's parent has consented to the child's participation by an employee of the institution of higher education or other school official, which basically means there's no parental rights if a college is involved. The section under Title 63 includes a whole new exception to health care decisions. Here, a person includes, quote, a corporation or any legal entity or commercial entity, whether or not a citizen or domiciliary of this state, whether or not organized under the laws of this state. And parental rights do not apply when, quote, a person participates or assists in emergency care. This is not a bill for parental rights. This is a bill of parental bondage. With all due respect to the sponsor, the bill has too many slippery exceptions to protect parental rights and protect children at the same time.
Thank you for your testimony. Are there any questions? Representative Harris, you're recognized.
First question is, Are we still in quorum? Because we've got a lot of people that just walked out.
We're out of session.
Okay, I just want to make sure before I be able to ask. So, thank you for being here. And so for the purposes of this, I mean, it is fairly long. But going back to what it is that you just mentioned, what are the points that you think that are harmful to a parent or the parent's rights?
Yeah, so
Ms.
I want.
Regula, you're
Oh,
recognized.
I'm sorry, thank you. I want to particularly look at this whole unless section about when a parent loses its rights. There's a whole section about law enforcement, forensic interviews, court proceedings, safety demonstrations. One of the big problems is in that section, there's no level of the standard that would need to be present before there was that state intervention. For instance, if a child is going to be forced to engage in a forensic interview or a law enforcement interview, there should be some credible evidence of probable cause of a crime or imminent threat. So, in other words, this just gives us blanket authority without saying that they have to have cause to do it, at least some type of probable cause. The other thing in particular, it talks about forensic interviews with children, and I think that children, it doesn't really provide that children should then have, and the family should have some protection of the child having an attorney or neutral person present while they're being interviewed in a forensic setting, because this could be anything from a 3-year-old to a 17-year-old. And then under the exceptions of academic, where basically consent is not required, it includes academic, extracurricular, et cetera, photo identification cards, things like that. Those clearly need to be with the consent of the parent, especially these days when we know that electronic imagery can go anywhere. That would help.
Representative Harris? You good? Any other questions? If not, thank you for being here.
Thank you, thank you.
Next, we're going to call up Mr. Jordan Carpenter. If you would come forward and state your name and who you're with for the record, please. Thank you for being here.
Thank you, Madam Chair, and good afternoon to the members of the subcommittee. My name is Jordan Carpenter. I serve as legal counsel with Alliance Defending Freedom. ADF is the world's largest nonprofit legal organization committed to protecting the rights of parents to raise their children without undue government interference. We're committed to this cause because children belong first and foremost to their families. Over 100 years ago, the Tennessee Supreme Court held that the relations which exist between parent and child are sacred, and that parents can't be deprived of the rights that correspond with those relations without notice and upon some ground which affects materially the future of the child. House Bill 2936 provides clear standards in support of these sacred relations between parent and child by defining the right of a parent to direct the upbringing, education, and care of that parent's child, declaring that right to be fundamental, which means that government interference with the right gets the highest level of scrutiny, and providing a legal remedy for parents whose rights have been violated. Because it is fundamental, the right of fit parents to bring up their children as they choose should receive top-tier protection from all levels of government. But ADF represents and has represented parents in Wisconsin, Michigan, Virginia, and other places where government officials have hid information, lied to parents, or otherwise interfered with the realm of authority that rightly belongs with the family. And while Tennessee has a historically strong record of protecting individual liberties, the state lags behind the 17 other states that have codified the fundamental right of parents to direct the upbringing, education, and care of their children. Passing House Bill 2936 would put parental rights at the top of the priority list in Tennessee. Because parents know and love their children best, the government's role should be to defer to parents except in extraordinary cases. In 2013, the Tennessee Supreme Court reaffirmed its commitment to parental rights when it said, "A parent's right to the care and custody of his or her child is among the oldest of the judicially recognized liberty interests." By passing House Bill 2936, the General Assembly can do its part to prioritize and protect parental rights in Tennessee. Thank you for the opportunity, and I'd welcome any questions.
Thank you for your testimony. Representative Harris, you're recognized.
Thank you, Chair. So with that, what about the kids that would be in DCS custody?
Mr. Carpenter?
Representative, that's always the question, right? The government has a role to protect the rights of parents. It also has a role in protecting the safety and well-being of children. That is a foremost consideration, and that's what these standards are for. That's why the balancing test, that's why some of the exceptions that the previous witness talked about exist in the bill as drafted, because there's always a balancing act between the rights of parents and the responsibility of the government to ensure that children are not abused or neglected.
Representative Harris?
So if a child who has, been in a situation where they may have been neglected in some form, reading this, unless there's somewhere else that I'm not reading, based off of it, it looks like the parent will still have the full rights as far as like the moral and religious training for the child, to direct the upbringing of the child, even if DCS has custody of that child.
Mr. Carpenter?
No, and I think that's where we talk about unless otherwise provided by law or court order. And there are plenty of places in the Tennessee Code where already parents' rights are infringed on based on circumstances relating to the child and preventing things such as child abuse or neglect. Now, it's kind of baked into the system that those things have been built based on the standards that this bill would codify, which is there's a compelling governmental interest and the government's actions are narrowly tailored to serve that compelling interest. So, as an example, there's a compelling governmental interest for Tennessee to prevent or address child abuse and neglect. It will use the means that it has through the court system, through other government activities to address that. Now, it just has to tailor those activities and those policies to make sure that it's serving the interests and not doing something else or otherwise unduly interfering with the parent's right.
Representative?
So from a DCS standpoint, if a child is in this situation here where we'll have one law that says that they have the rights to all these parental rights, but then we'll have other laws. So basically, a child will be in a court battle going back and forth because one party is going to sue DCS, and then DCS is going to be taking the parent to court, vice versa, based off of this legislation. So we're just going to have just open cases just going back and forth.
Mr. Carpenter?
No, I think this bill simply codifies what already exists at common law throughout the state and federal court systems. So the interactions with the state that parents already have through DCS or child welfare cases within the custody battles, all of these standards are already built in. And so they can make those arguments in court already. But this provides an avenue for parents who feel like their rights have been violated. Maybe there's not already a case pending against them. Provides them access to address those violations in a way where clear standards are set and parental rights are prioritized in this state.
Representative?
So I guess my last question is, and I was talking about this earlier, but the parent still has these rights until the court rules otherwise. In a lot of cases, and here I'll use, for example, on number 8 says that the parent has the right to participate in parent-teacher association and school organizations that are sanctioned by the Board of Education of a local education agency. So I still, even though my child is currently under custody with DCS, I'll still have the right because of this law to be able to go to parent-teacher conferences, to do all the stuff I would like to do with my child, even though my child is technically in the custody of the state.
Mr. Carpenter?
Thank you, Madam Chair. Again, the many of the enumerated rights here, it's the consensus view of what the parent's right to direct the education of the child, for example, is. So the right to direct education is the right to choose the setting where your child is educated, to participate in the academic process, and to make reasonable choices within the curriculum setting. So those things are already in the system. They already have case law that support those things. This is simply laying it out in the Tennessee Code to say the legislative branch is not only endorsing this, but saying this is what we want to be the public policy of Tennessee, not subject to judicial interpretation.
I don't have anything else, but I do think that this will probably cause some headache for DCS for sure. I don't know if they're speaking on this, but definitely would have some questions for them if they're not.
Representative Bricken, you're recognized.
Thank you, Madam Chairman, and those are awfully good questions. So, background, what organization again are you with?
Thank you, Madam Chair. Yes, sir. I work for Alliance Defending Freedom. I'm an attorney.
Okay, so ADF is your acronym, or?
Yes, sir.
Okay. Are y'all the source of this legislation?
Mr. Carpenter.
The source of the legislation is obviously with the sponsor. I have worked with the sponsor to ensure that we work within the function, the structure, even the syntax of the Tennessee Code, that it doesn't conflict with laws as they currently exist. So I wouldn't say we're the source, but we definitely have worked with the sponsor.
What,
Representative Bricken.
thank you, Madam Chairman. You mentioned 17 states. Have they passed similar legislation as being proposed?
Madam Chair.
You're recognized.
Yes, sir. So 17 states have codified and used the words that the right of a parent to direct the upbringing, education, and care of that parent's child is a fundamental right.
No, and that's not a
Representative
question.
Bricken.
Thank you, has 17 states passed legislation directly like this? And almost, is this a uniform type of legislation that your organization is sponsoring across the nation?
Mr. Carpenter.
It is substantially similar to those other 17 states. Yes, sir.
Okay.
Yes, sir.
Representative Bricken.
And when was the earliest of that legislation enacted in any other state?
Mr. Carpenter.
Many of the states have had statutory language that's substantially similar to this on the books for decades. Colorado is a good example. Even West Virginia has a statute that harkens back to 1870. So there are some statutes on the book. A lot of the parental rights litigation arose in the 80s and 90s when states were passing grandparent visitation laws or other things that infringed on the rights of parents. That's when a lot of the lawsuits dealing with this issue. And then since I'd say the 90s, states have considered this type of legislation. I'd say the bulk of those 17 states have passed their legislation in the last decade.
Okay.
Representative Bricken.
That's kind of, I mean, I kind of wanted to get a little bit of the historical possible background of this type of legislation, because I'm going to say, as well-meaning as this is, I think we all want to certainly support the family rights and rights of parents. It's just hard for me, I'm going to say, to believe that we can cover all the issues in legislation, and therefore we will be continually adding to this or striking from this as we go forward, which may be what we're supposed to do up here. It just seems, I just don't know how we codify everything under the parental rights that we probably need to. So that's more of a statement.
Might I respond to that, Madam Chair?
Yes, you're recognized.
So the broad language is taken from court decisions that discuss parental rights. And a lot of them, the earliest cases, have to do with the government taking people's children. Then later on has to do with the right to educate your child the way you see fit. And like I said, there was another spurt of activity with grandparent visitation laws. But the wording has remained consistent from the U.S. Supreme Court and state Supreme Courts for over 100 years. So that's the broad language. There is a little bit more filling in of the lines, I guess you could say, with the enumerated list. But it by no means is it exhaustive, or does it intend to be exhaustive to say this is a list of every single right that a parent could claim under this statute or under the principles that have been used to defend parents' rights in the last century. But it does provide a nice framework to say this is what is clearly the public policy of Tennessee, what we support parents' rights to do in our state.
Any other questions? Representative Carringer, recognized.
Thank you, Madam Chair. I'm trying to review, as you've been discussing this particular piece of legislation, I got kind of several questions. First of all, the Parent Code of Conduct or Family Rights and Responsibility Act, that sounds fabulous. We all want to be able to be free of any government interference on how we raise our children. So I think the concept is certainly admirable, and I appreciate your organization doing that. But there's several parts of this legislation that I'm not really even sure what it means. Okay, but before I get to that, can you tell me a specific incident in Tennessee that you're aware of where either the government entity or a healthcare provider that you're opening up a direct action against to under this bill? So it's not just codifying what's already there. I mean, we've got some actions here that a healthcare provider can lose their license. You can have a direct civil action against them. There's a lot of things in here that's creating causes of action that's not particularly just out there right now. So to broaden the ability to sue, what has happened right now in the state as an example to a parent that you know or that we may know that this has happened to, that there's a real example out there that's saying either the government in their form of making sure we protect parents and protect children, or there's an entity out there that's violating someone's rights right now to parent their own children?
Mr. Carpenter.
Yes, as I said, ADF represents parents across the country where this has been the case, where mainly school employees have violated the rights of parents. Personally, I grew up in Shelby County and spent most of my life there. I have personal knowledge of non-public instances where this has happened as well, where a teacher has said, I'm going to talk to your parent in the next few days. Should I be using your given name or the name you've told me? Which pronouns? What should we be talking about? Are there topics of a conversation that I should or should not cover with your parents? That's the type of thing that a parental rights law that's clear and sets clear standards would address. Not only because it would open up a right to sue the school district for either having a policy that allows for that or not stopping their employee from doing something like that, but also because it reminds the government employees what their role is and what rights parents do have, so that as they interact with other people's children, they don't assume responsibility that they haven't been given.
You're recognized.
Thank you. So just for instance, and I'm going to be very simplistic, I'm not going to get into the pronoun argument, but if my son is named Jackson and a teacher wants to call him John, and that offends me because they're not calling him by his given name, your legislation would give rise to me suing that teacher directly, personally, in her personal capacity or their personal capacity for violating the given name that I've given my son or daughter. Is that the intent of a parent code of conduct, where if something simple like that, where his name's Jackson, but they won't call him Jackson, they'll call him John, that I can sue that teacher or that entity or that person directly? Is this what the intent of this legislation provides?
You're recognized.
I would say under those set of facts, no, that's not what this intends. And the legislation as written doesn't decide, well, a parent's unreasonable claim will win in court, or the government's claim will win in court. It simply sets clear standards. So the parent would have to articulate what right they're looking for. I want my son to be called Jackson rather than John. The court would evaluate whether that's a reasonable claim under the standards of the law, and then people would present proof, obviously. But I think that that seems like a rather minor topic, but that's not what we're dealing with. We're dealing with government entities, agencies, institutions that actively hide or otherwise lie to parents about their children, and meaningful things, not here's what I'm calling your son or daughter, but is your son a daughter? And those are things that parents shouldn't be left out of, and those are issues that give rise to legislation that protects parents' rights.
You're recognized.
Thank you, Madam Chairman. And I think you somewhat proved my point. I purposely came up with a pretty simplistic example that can be captured under your piece of legislation that would give someone the right to file that action, which it's relatively minor. That's one of my concerns with the way this has been drafted. And I'm going to quote a sentence under 36.8.104 where you provide certain rules should be followed, and you're providing the judges certain instances, either one at the trial court level or if and when this is ever challenged, what they're supposed to do as it relates to analyzing the constitutionality of this particular piece of legislation. In number 3, it says if a child has no affirmative right of access to particular surgical, medical, or mental health procedure or service, then this act does not grant that child's parent an affirmative right of access to that procedure or service on that child's behalf. I'm going to be honest with you, I don't even know what that says. I don't know what an affirmative right of access to a particular surgical, medical, or mental health procedure for the right of access for a child. So you've got some strict ways to enforce this or follow the rules, but yet the words that are written here are very hard to determine what the legislation does. Do you see that as being a problem with this, or is that something where I'm just not reading into the language? And it's throughout the language. So I want to make sure that if we're going to get a parent right of or a parent code of conduct, or how you've named this piece of legislation, that it can withhold some issues if it's ever challenged. Do you see that paragraph and can kind of explain to me what that means?
You're recognized.
Sure, there are plenty of things that the state of Tennessee has said are off limits for children, whether it's alcoholic beverages, lobotomies, tattoos, or as a concrete example, what this body passed into law last year is a transition procedure or hormone blockers or wrong sex hormones given to minor children. Well, there are arguments out there that parental rights, the right to direct your child's care, would open up that avenue to say my right as a parent trumps the government's responsibility to protect children from harm done through experimental, dangerous, harmful medicine. This makes clear that that's not what this legislation does, and it says in Tennessee, not only is there a limit to parental rights, but the government's reasonable regulation of medicine doesn't even impact parental rights. That's what that language says.
Those are all my questions, Madam Chair. Thank you.
Any more questions? Seeing none, thank you so much for being here.
Thank you.
I think DCS wanted to just, we can go back into session if you want to. We're back in session. You're recognized.
Madam Chair,